Okay, ladies and gentlemen. We got a quorum, so let's go ahead and get started. If you'll call the roll, please.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot. Okay, we have a quorum.
Okay, we've got Senator Bell here now. So first one on the agenda is SB 309.
Thank you, Mr. Chairman. I am bringing this bill today. It's, sometimes we pass bills and then we have them a couple of years and we realize that they need a little tweaking. And I had this bill originally when I was down in the House as the health chairman, and Director Delamont and I had worked together on addressing an issue that the Department of Forensic Sciences was having with fentanyl and doing some work with the fentanyl cases that they were getting. So over the past couple of years, they've worked and we've created this bill based on some issues that they're facing that we need to update. As a point of reference, the Department of Forensic Sciences has tested thousands of fentanyl mixture cases, and over 60% of them are a mixture of fentanyl and 4-ANPP alone. And so 4-ANPP is fentanyl's immediate precursor. And if we get too much into the chemistry of this, I'm going to have to call on some help back there. But basically, we address issues with these synthetic controlled substances, and the bad guys are very smart, and they change the compound of them, and forensics has to continue to deal with that. So this bill addresses the issue in our current law, which does not adequately provide for situations where there's a possession with intent to distribute and trafficking in fentanyl mixtures that are solely comprised of fentanyl and this 4-ANPP fentanyl immediate precursor. So this would clarify that if the detected weight of fentanyl as a single compound and or a mixture with another synthetic fentanyl analog or the 4-ANPP was more than a half gram but less than 1 gram, the proper charge would be possession with intent to distribute fentanyl, and if it weighed more than 1 gram, it would qualify for the trafficking of fentanyl. So happy to answer any questions.
Senator Smith.
Thank you, Mr. Chairman. Isn't fentanyl, what is it? Fentanyl? Fentanyl. Isn't it, though, in some cases legal? I mean, I was listening at the news, the morning they said they gave somebody some, it was like.
Certainly we use it in the healthcare setting.
Yeah, that's what I'm saying. So now
this is when it's out on the street.
I understand. But what I'm saying is that how are we going to distinguish that it is or isn't? Because if that amount, it can be used legally under legal pretense, then if we just blanket, is there anything that delineates the difference of what, you hear me asking this question, is it something in the bill so that if there's a circumstances where I can only use this, I know in this extreme it would apply, but a medical provider or somebody who can issue the fentanyl, you can't understand. Do you get a feel?
I do, and certainly, as with any controlled substances, if they're used in a healthcare setting under the guidance of a medical professional, that's a different situation than when they're buying and selling it out on the street, and when he's finding it in these autopsies.
But I'm still saying that if there anything sets it out, we know generally if you can't be using it illegal versus legal, but where is that distinction that separates from where it is to legal or illegal? Is that in this bill? That's what I'm saying. I mean,
so a lot of that stuff is going to be regulated by the licensure with the BME and the authorities who regulate the prescribers. And we've done a lot of work with regulating prescribers over the last decade here, everything from creating that PDMP to looking at how we address the prescribing of these very dangerous controlled substances. So I feel confident that that is outlined, maybe not specifically in this bill, but with the administrative rules and regs with the BME and other places that regulate providers.
I understand, but I don't see the proof. I know I just our feelings. You know how that is, and when we back here now with it, okay, that's what I'm saying. It was obvious there was something there when we did it, and you did it initially. That now we got to come back, and address, and all I'm just saying that I there again, I'm back on my airplane and the wings. Yeah, the plane, we want to knock this fentanyl out. We want to make sure we deal with that. But the consequences, if somebody's over here that has that falls in this category, I would hope that between now and we go on the floor that you can just pick up your folks and they can tell us what the answer to that, the actual answer to it. Not our opinion, kind of we feel like, but to say that yes, under the reg 2, 3, 4, 5, it says that you can do so and so and so. So if it's there, I think if they, if they're interested enough to get you to change that, they surely know the process and the regs and everything. So if you could do that, I'm gonna support it. But if you can do that, because I just don't want to set up a scenario that we're wiping legitimate people out, running at the crooks. You know what I mean? It's not like that's why I say it's the airplane. We just looking at crooks and we trying to get them, but we don't know what's happening over here as a consequence incident of trying to actually go get them.
And I may not be articulating that correctly. Would you allow Mr. Delamana to answer or add to what he's saying just in one
Sure.
quick minute or so?
Just want to make sure those fentanyl patches for, bad backs aren't covered.
Yeah.
There you go. Before you even said something, now I'm so glad you said it because I couldn't think of it like that, and that's all I'm trying to do. I just want to make sure that you don't get something over the counter, something you all of a sudden get zapped.
Yes, good morning, Senators. Yes, the lawful prescription, so there's a very narrow category where fentanyl is prescribed in those patches, typically terminal patients in hospice for pain management, et cetera. That's not what Senate Bill 309 addresses. Senate Bill 309 addresses when they were making the fentanyl powder. So just like when you're baking a cake, you're adding, if you needed 2 cups of sugar, but you added a pound of sugar, you're going to get the cake with a lot of leftover sugar. And that's what the precursor is, which is by itself controlled. And so fentanyl also is controlled and the precursor. So you have a mixture of 2 controlled substances and what we're seeing on the street in the powder and all the undercover buys. And the penalties and the charges for mixtures of fentanyl, you need a higher weight than just pure fentanyl. And that's actually backwards, right? You would want pure fentanyl to be the higher charge. And now with the synthetic fentanyl analogs that we are seeing across the state, they're actually more potent than just fentanyl when you first passed the original fentanyl statute. And so Senate Bill 309 simply puts, if it's a mixture of the leftover ingredient that made fentanyl, which is controlled, and fentanyl, then it's treated just like fentanyl, because that's what they're intending to make. If it's a mixture of acetaminophen and fentanyl, et cetera, then it stays the way it currently is. It doesn't touch any of these other mixtures, methamphetamine and fentanyl and these other cases that we're seeing.
Is it a threshold of, lack of a better word, the threshold of pureness for the leftover that is measured to determine that just simply because it's just leftover, that it just is automatically what we're trying to pass here versus you all go in and say that, because I don't know what the percentage is by memory of, how she's changed from trafficking to possession to
Right.
that. I don't know what that is
Right.
in this scenario. So is there a law or regs or procedure that says that in this leftover, when y'all run it through y'all process, and then it says that it's 32% fentanyl, that hits the market, that hits the bail, that this is whatever it is we trying to do here. Is that a measurement there that you all go? Could you tell us what it is?
That's right, Senator. So it's a weight because the only purpose of that 4-ANPP, which is by itself controlled, is to make fentanyl. That's the way it's converted. Okay. So if we detect 4-ANPP and fentanyl, then it's treated just like fentanyl, right? And the weight for trafficking is 1 gram or above.
Is the stuff that you're treating like fentanyl, is that controlled?
It is.
And so it's
For
controlled
it.
just like fentanyl. It's
Correct.
different than the
So what
fentanyl.
happens currently is when we detect, we get an undercover buy and there's a bunch of powder of fentanyl, okay? They believe it to be fentanyl. And we detect 4-ANPP and fentanyl. That's a mixture of 2 currently controlled substances. So that's required now to be 4 grams for trafficking. If it's just fentanyl, it's 1 gram. But that mixture is actually more potent than fentanyl. And the intent is to make fentanyl. It's just left over. So this bill, Senate Bill 309, just treats that scenario as single component fentanyl.
So that's what you're trying to do here.
Correct.
You're trying to say that mixture part, that actually the fentanyl is supposed to be dealt with harsher than the mixture.
That's right.
And right now the mixture is dealt harsher than the fentanyl.
Correct.
Thank you very much. At the proper time, I want to say aye.
Well, I think the next was, gentleman is on the phone, so we'll go with Senator Bell. All right. Second, Senator Albritton, do you want to add anything?
Yes, sir. I must opine on this, if I may. Look, I've looked at your bill, and as my estimation, looking at the sentencing that we've got back on page 15, you got a mandatory life sentence at one point on this, and also steps up on each one, almost like 3 strikes you're outlaw, like we used to have. This is going to increase the number of prisoners we take in and keep. Is that right?
So it mirrors what is currently in the statute for the single component. That's the current law. And
All these are underlined, though. I thought that was added.
it adds for the mixture of that leftover scenario that I described. It
Exactly.
treats it just like single component.
All right, so you get for 4 grams, you get 3 years. For 14 grams, you get 10 years. For 28 grams, you get 25 calendar years.
Mm-hmm.
And then for 56 grams, you're mandatory life. And then you've got further other aspects. Now, I'm fine with putting folks away, but my point is that what we have to do is understand that this looks like we're going to be increasing the number of prisoners that we have for longer periods. Is that a fair statement?
I don't know the answer to that because currently this bill addresses that scenario where they're between the 2 grams and 4 grams. So it's a very narrow window of what would be considered a mixture or single component, right? And
I've heard that, but also I'm looking at the page 15 with all this underlined. Again, I think the underlined is new language. And then upon the 3rd or subsequent conviction, any additional penalties provided, the person shall be sentenced to an additional 10-year term. So it seems to me that we're increasing the incarceration time. And again, that's fine with me. I just want the body to understand that if we're doing that, it's probably meaning we're going to be keeping more people for longer periods, which means that we're going to be having an increase in our prison level. And we're trying to prepare for that, but I just want to let folks know that that's what I think is going to occur. And I just want to know if am I on the wrong track there?
I'm certainly not involved in the sentencing part, but I think that the bad actor would be going away regardless. And this is the scenario where if it's the
Going
leftover,
away and keeping him.
regardless.
Yeah, okay.
Correct.
Thank you.
But Mr. Chairman,
Well, Senator Smitherman had his hand up first. So.
Thank. I'll leave. So what?
Attention first.
No, I yield. Go on. No, go on.
Senator Coleman Madison.
I still will be recognized.
I just want to be clear about what this bill is about. And I don't have necessarily a problem with the sentencing. What you're trying to do, because we know that fentanyl, even from what I understand, I don't know a whole lot about the drug, just a pinhead is very dangerous. So we're talking about repeat offenders. And as far as locking people up, okay, you know, after the first time you're going to get locked up and you go back the second time and have 3 strikes and you continue to do this, but at the same time, it's about the person that's distributing it. The end game for me is the people that end up consuming it, some children, whatever, and they could be dead. So I don't really have a problem with the bill. Kind of like you don't do the crime, you don't do the time.
Senator Singleton, were you trying to get my attention for your neighbor or yourself?
No, I was really it was a statement that he made when he said that he doesn't get into the sentencing process, but it is in the bill. Right. So you are in the sentencing process. It's in the bill. You're telling us what's going to happen. That's all I just wanted to say. So let's not make those kind of statements to us. If you were leaving it to judge's discretion, then you wouldn't have all these sentences in here. That's all.
Senator Smitherman.
Right.
That Senator Singleton, not the statement, but what last words he said. That's fentanyl. I just told you how I feel about that, so that's fine. But I want to just say a general statement because sometimes we hear it down past. You know, I'm not comfortable with taking discretion of sentencing away from a judge, and that's what we're doing in here. We said mandatory, so and so. I mean, the judge has no discretion. And I think that you have to hear facts to determine whether that particular situation ought to be applied like we're doing here. And here we just saying a blanket thing. Even if somebody pleads to it, I mean, that's what's going to happen. There's no room. There's no room. Even if you're trying to get an informer and trying to get something, I mean, they have no room here.
Chairman.
You know, they have no room for anyone to do that. It could be 2 or 3 people. You actually trying to get the mule, as they say, the big person. But if this person's going to get live anyway, I mean, they're not going to say a word. And so I do have a problem with this and anything else that's brought. It's going to be saying mandatory that you're going to take discretion away from the judge. So that's my problem, and that will remain a problem as we go through the process. In terms, I'm going to vote for it because I agree about what we're trying to do. But I am a staunch person against taking discretion away from a judge, period.
And the boss ain't on the bench anymore, and you're still saying that. So you're consistent.
I'm still consistent, that's right.
Senator Figures.
Thank you, Mr. Chairman. I'm going to vote for the bill, too, because I'm all about getting those sellers and traffickers off the street. My concern is, are we treating this crime differently than we do other crimes that are heinous crimes, or even more heinous, if you will? But of course, selling drugs, it ends up being that way too. But I think at some point we need to look at how we are sentencing people. It needs to be treated the same for those same type terrible crimes. But that's my concern is, I mean, or do we try to find a formula to deal with this? Because this kind of sentence is not even in some of the laws dealing with children when we abuse them. So that's my concern, is that we don't treat everybody. You know, we can work on that along the way, but.
That's a great point, Senator. So just to clarify, when the legislature passed the current fentanyl statutes, there's mandatory minimums now because the legislature thought and recognized that fentanyl is a serious drug and needs to be treated as such. And so the current mandatory minimums are there. What Senate Bill 309 does is it treats the mixture of fentanyl and the leftover the same mandatory minimums as just fentanyl. The discretion for fentanyl mixed with methamphetamine, marijuana, acetaminophen, that judge's discretion, all that's still there. The mandatory minimums that are currently in place are now going to be treated the same for single component fentanyl or fentanyl and the leftover precursor in Senate Bill 309.
Okay. Senator Weaver.
So I appreciate everyone's comments, and I would say that laws like this, I hope, would be a deterrent for people who are trafficking fentanyl and are getting them in our communities. And on behalf of all the constituents that I have that have lost family members to fentanyl, I think that they would say that they certainly agree with trying to include the mixture as well. And certainly, I think we all agree that fentanyl is terrible and it's really harmful to our communities. And if we get this out today, we would be willing to sit down to work through some of the concerns just to make sure that we get to a point that these mixtures are included, like the pure fentanyl, in the way that it needs to be.
Senator Singleton.
Yes, Mr. Chairman. And while I agree with you, and this is not directed at you, but in the 1980s, crack cocaine killed the black community. And to this day, nobody has come to us about what crack cocaine still does. I wish that y'all would take that very serious like you do fentanyl, meth, and all these other drugs that you see that are killing people. It killed a generation of our people in the African-American community. And nobody from the DA's Association, and I've said this over and over again, even when Democrats was in power, that no one from y'all community came and talked about crack cocaine and what the effect that it had on communities. And you still haven't done that. Thank you very much.
Mr. Chairman.
Senator Figures, I will just say, Richard Pryor had a pretty good joke on that back in the 70s. Senator Figures.
Thank you, Mr. Chairman. My question was going to be about the deterrence. And we pass laws and we do these penalties so that they will hopefully deter people from doing the crime. And as we know, even the death penalty does not deter people from continuing to do the crimes. But do you have any data, perhaps from other states, whereas they have this in place, and if they have actually seen a difference in lowering the traffickers? And
I don't from other states, but I do have our own data from our medical morgue facilities around the state that even though the overdoses are down, we get about 2 to 3 overdose deaths a day that represent to our morgues, right? And over 80% of those have fentanyl or an analog or these other components in it. So it's certainly still affecting the communities across the state. But as far as other states and their sentencing and restrictions, I don't have that data.
my last comment, Senator Singleton, you definitely brought the point home that I was making about all crimes being treated the same. Thank you. Thank you, Mr. Chairman.
Okay. I do have to get out of here for our House committee in a little bit, but Senator Elliott.
I'd like to move favorable report on this piece.
I think we already have a favorable from
I'd like to
Senator Bell and a second
call the
from
question
Carnley. And if no other comments, if you'll call the roll, please.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver,
Aye.
and Senator Barfoot.
Aye.
It's favorable.
All right, Bill's given favorable report. Thank you, Senator Gavan. Sorry for my tardiness. Moving right along, we want to remind the members and the folks in the audience here, as well as the other bill sponsors from the House. We do have Senator Gavan's going to be leaving here shortly. Hopefully, he'll be able to return. We do have a Banking and Insurance Committee meeting at 9:30. I will commit to you that as long as we have a quorum here, or as long as I'm not pulled out to make a quorum in that next meeting, we'll continue. So, Representative Faulkner, HB 192, if you can, give us a brief description of what your bill does, and we'll open up for questions.
Thank you, Mr. Chairman. Members, this bill makes a revision to 13A 3-23 that's existing law. And what it does is, if you are claiming you used a weapon in self-defense, then if you do not have that weapon, there's going to be a rebuttable presumption that you did not use the weapon in self-defense. And that, in a nutshell, that's all this amendment to this law does. You can, let me add though, you can overcome the presumption. So if you don't have the weapon that you say you used in self-defense, you can overcome that. There are circumstances. Hey, I was on a boat. The weapon went overboard. Somebody grabbed it, ran off with it. But which you can meet before the judge, and it's up to the judge. But it puts a rebuttable presumption if you do not have the weapon that you need to overcome. If you have the weapon that you used in self-defense, you turn it over, and there's no presumption against you. But if you don't have the weapon, this presumption exists, but it can be overcome. All you have to do is present the facts and to the court that why you don't have the weapon.
Senator Bell, then Senator Smitherman, and then Senator Albritton. Senator Bell.
Representative Faulkner, I've handled many of the stand your ground hearings in self-defense, and I think the bill makes sense because if you destroy the firearm or if you destroy something, it's kind of hard to argue self-defense in a case. It's kind of hard for me to look at a judge and argue if self-defense when my client has destroyed the evidence that he's claiming self-defense. So I've probably handled 8 or 10 of these hearings, and so it makes sense. Thank you.
Thank you, sir.
Senator Smith.
Mr. Chairman, I'll yield to Mr. Chairman, then you come back to me.
Senator Albritton.
Well, you know, I've
That
had a
sounds like a
chance.
setup, but
No, not for you, it's not.
I would challenge you on one statement, Representative Faulkner. According to what this says, it's not a matter that if it's stolen or goes over or something. This says that the presumption will be in place unless the weapon is voluntarily provided to the police.
That's correct. The presumption's in place unless that's correct.
I don't see if there's any other absence that allows for an overcoming of that presumption.
Well, that's what a rebuttable presumption is it is rebuttable.
But it says here, at any time the defendant concealed, altered, destroyed, or otherwise disposed of commission of alleged offense other than voluntarily providing the unaltered deadly weapon or dangerous instrument to law enforcement, there shall be a rebuttable presumption.
That's right.
All right. Now, I think that's a high standard. The other aspect is how long does this last? I mean, if the event occurred and he has that possession, because there is no statute of limitations on murder, so does that mean he can never sell that firearm again, or he can't pass it to a child or give it to someone else?
No, I mean, no. So you would be, whether it's a pretrial hearing or whether you claim self-defense in trial, you would simply, as long as you, to law enforcement, you say, hey, this is the weapon I used. As long as you're willing to have done that, then it's just like any other case. I mean, until they say they don't need the weapon, but
what you're trying to get to is a point that someone uses the weapon and then tosses it somewhere, tries to get rid of it, or tries to clandestine way of or alter it in some fashion. I understand that, but I think this presumption goes a little bit too far. I'd like to see some protections or some specifics as to what it could occur or on how the presumption can be overcome. That's my only comment.
Yeah.
Senator Smitherman.
No, I with all the concerns that I've heard, I was going at the proper time just move for favorable report. I say this, you know, I personally understand what Mr. Chairman is saying about that being an attorney as well, and I would hope that you would work with that issue to see how you can still do what you're trying to do, but address that issue. Because, you know, I'm not saying we're the only ones in here, but I know all three of us are lawyers. And so you can have an appreciation for what he said.
Absolutely.
And the other caveat I wanted to say that, you know, that's a great representative right there. Senate District 18, one of my reps. So I got to be with him.
Thank you.
I hope, I was thinking you were going to be my Senate sponsor, or is it, I don't, maybe consider.
We'll work with it. All of us will. Between all of us, we'll tag team it.
Got a first by Senator Smitherman for favorable report, second by Senator Elliott. Any opposition using previous role? Hearing none, bills given favorable report. Thank you.
Thank you, Mr. Chairman. Thank you, members.
Sure. Next up, ladies and
I'll
gentlemen,
bring
I've got SB 178 and 179. I'm going to ask Judge Naftel to come if he's here. PR. If Judge, if you wouldn't mind coming up. Judge, as y'all may know, I was a retired probate judge. Had some insight on the dealings of the needs for probate work and things that affect people throughout the state in the probate side of the equation. Judge, if you will, help me explain SB 178. These are ALI bills.
Sure. These are super nerdy, so apologies to the gallery. SB 178 changes one sentence, I believe, of the Principal and Income Act relating to the way a fiduciary allocates income and principal and receipts and disbursements in a trust, and it's just keeping up with current best practices. It used to be that when you created a trust, you had to follow strict rules. If receipts were, rental income or interest income or anything like that, you had to allocate it either to principal or income for purposes of filing your taxes. And in the last 30 years or so, those rules have been liberalized by the IRS. And so all this does is bring our Alabama Principal and Income Act into conformity with those best practices, where a trustee has the ability to adjust the way it characterizes receipts and disbursements with ongoing and unassailable duties of impartiality and fairness to the beneficiaries. You can't do this to game the system. In fact, you do this because the way the trust may have been set up back in the 80s or 90s may not end up being fair under current circumstances. So this is just a little tiny tweak to make sure that we're keeping in line with best practices on the Principal and Income Act.
Judge, nerdy indeed, but I'm glad we've got people looking at that. We've got a first by Senator Orr, second by Senator Elliott, and then discussion by Senator Smitherman.
I wanted to make the motion.
Oh.
And you said I was first, and he beat me to the punch.
Okay, well.
So I'm just gonna be the second.
You be the second.
The second one.
Okay.
But I really wanted to make a comment and say this, and I believe you're supposed to give folks flowers while they're living. Somebody dead, you standing all over and talking about, oh, he was so nice. They don't hear you. They gone. So I'm gonna get Judge your flower while he living. If you want an expert in this field, you know how we be talking about bring the expert in. That's the man right there.
We've got him.
I just wanted to tell you that he's the man because he was our probate judge up there, and man, if he said what he just said, I'm ready to say aye. Okay.
Senator Coleman Madison, did you have a
I do
comment?
have a question. I'm not one of the learned attorneys around the table, just a layperson, so I do want to make sure I understand this. And when I read it, it seems like the trustee has a right to make changes to an agreement that the trust was not aware of.
Under
Explain how that would work.
under the current rule, before this, unless this passes, the current rule in Section 104 says a trustee has to explicitly be given the power to allocate or adjust between principal and income. This changes that to where that power to adjust is now the default rule. So a trustee can do that even if the trust doesn't permit them to. And that's, again, all of the states around us have made this change. The Uniform Principal and Income Act made this change years ago. We're just behind on this. And the reason, again, for that is that, allocating income and principal is not as simple as it used to be because the character of investments is different now. When you invest in certain kinds of funds, you get income from that, but you've got to decide, am I going to allocate that income to my trust income that I then have to pay taxes on, or can I allocate some of that to principal to keep building the assets of the trust and not have to pay taxes on it yet? And, for your beneficiaries, it's a question of, does my income that I would otherwise receive from this trust take a ding on some additional taxes, or if can I get a distribution of principal that I don't have to pay taxes on? So it allows the trustee to balance those considerations in a way that is more fair to the beneficiaries and, hopefully more advantageous to them in the long run.
Is there a point in time when the trust is notified or sent something that this is happening, this is done for your benefit? I understand what you're saying.
Yeah.
But it's just a matter of notification of this was done. I understand you don't have to go back and ask for permission,
Sure.
but I do think they need to know and understand.
Yeah, so under the trust code, beneficiaries are entitled to at least an annual statement of what the trustee's been doing, right? And that law was changed back in 2006, effective 2007, where a trustee can't hide what it's doing from the beneficiaries. You have a right on reasonable notice to say, hey, I want to see your books. I want to see the tax returns you've been filing. I want to see your bank statements. I want to know what's in this trust. I want to know why you haven't been distributed to me, but you've been distributed to my brother, or whatever the circumstances may be. So yes, they do have a right to know how this is being, used by the trustee.
I guess most people just look at it, am I losing money? Am I gaining money? So it's a flat line. So most people just look at that point, which is a red flag always.
Right.
Thank you.
All right, members, seeing no other hands raised for discussion, we've got a first and a second. Any opposition using previous roll? Hearing none, bill's given favor report. Thank you, Judge. Stay there if you will. We've got next one up is SB 179. I'm also carrying that. If you would give us a brief detailed description, and we'll open up to questions.
Okay. Well, if you thought that was interesting, then you just wait. All right. So this changes two sections of the trust code, and again, the goal here is to keep up with what states around us are doing and with current best practices that the IRS has permitted since the last time we changed this law. This is driven by banks and trust companies coming to our trust and estate planning lawyers and saying, hey, we're losing business to Tennessee trust companies that are coming down here, and they're saying, hey, don't create your trust in Alabama, create it in Tennessee because we have more favorable treatment of beneficiaries and more favorable tax laws. And so all this is doing is looking at what the IRS has done over the last 25 years or so and bringing our trust code into conformity with those best practices. In particular, what this does is it improves the tax treatment of the trust and the beneficiaries. There used to be all these sort of arcane rules where if you were a beneficiary and you had the right to request a withdrawal, like every year, the trust instrument said, you, Jim Naftel, can take $10,000 out of this trust. Even if I didn't take that $10,000, I would still be taxed on that $10,000 as if I had taken that distribution because I had the right to. So even if that money never came into my pocket, I still got taxed on it. All these changes do is change that so that unless that money actually hits my pocket, I'm not taxed on it. Okay, and and I could nerd out on this stuff for a long time.
Thank you, Judge. Motion for favorable, Senator Singleton, second by Senator Smitherman. Any further discussion? Seeing none. Any opposition using previous roll? None. Bill's given favor report. We may ask for a waiver to you to come on the floor and present the bill to the Senate as a body as a whole.
I'll be
Did
there.
a great job. Thank you,
Yes,
Judge.
thank you.
Up next, SB 237, Senator Singleton.
One of our professors was to come up with a cure for cancer. Right now, he could not use his intellectual property to be able to profit from that. Only the university can. So we're losing researchers leaving our state, going to other states to where they can be able to work on research to be able to make those profits. So this will allow them, under our ethics rules, not looking at it as being double.
Thank you for bringing this. I
Move
think
for
it's
favorable.
important. Got a motion for favorable by Senator Figurs, second by Senator Smitherman. Any discussion on the bill? Hearing none. Any opposition using previous roll? Hearing none. Bill's given favorable report. Thank you, Senator Singleton. Yes, sir. HB 10, Representative Pettis. This is different than the HB 11 that you've been here a couple of times on. So, but give us a brief description of HB 10.
Currently, under Alabama law, if you have a driver's license at 14 on a motorcycle and you're stopped, they cannot write you a citation. Same thing on a jet ski. If you have a license and you're doing something illegal, they cannot write you a citation. All this does is says a 14 or 15-year-old can be written a citation just like a 16-year-old on a traffic offense.
Members, any discussion on the bill? A motion for favorable, Senator Orr, Senator by Senator Smitherman. Any discussion? Hearing none. Bill's given favorable report. Thank you.
y'all.
All right, next up, HB 107, Senator Givens. Hey, good morning.
Good morning.
Senator, House member, I don't want to demote you. Representative Givens.
Well,
Tell us
thank
about your bill.
you. Thank you for allowing me to be here. So 107 is a distinctive license plate for military combat action, and there's eligibility criteria for individuals to receive this plate. You have to have served in a component of the United States Armed Forces and received combat action ribbon, combat infantry badge. Oh, okay. Good.
I have a question.
Let's roll. Let's don't entertain Senator Elliott's question.
We got a first by Senator Smitherman, a second by Senator Bill, Senator Elliott.
Senator Weaver, you have a committee that deals with license plates, if I remember correctly. So can you talk about that committee and how it relates to this bill?
Well, I'm sorry, I was a little distracted talking
Well,
to
he'll
Senator
do
Orr.
that to you.
So, yes, I am the chairman of the License Plate Oversight Committee, and we vet all requests that come through related to license plates. We work with ALEA to make sure that they are visually appropriate, and the Department of Revenue manages the financial piece of it.
Has this particular license plate gone through your process?
It's going to have to go through.
I'm not aware that it's been through that process, has it?
No, I was not aware that it needed to be.
So is it an application for a distinctive license plate?
Yes.
Yeah. It's just, is it the establishment of the tag, or is it just for penalties? Because if it's the establishment for the tag, that is what we would deal with, but this.
It is.
Is it just penalties, or?
No, it's for the establishment and penalties.
Ah.
It's going to still have, even if you pass, it's going to have to still come to you to go through all the criteria.
I don't think so. No, it doesn't. We had one. Yeah, if it goes through legislation, it never comes through our committee. And so we do have several members of that committee who are on this committee.
I am on it. I
yes.
thought it would still have to come through us.
Yeah. So,
Well, I removed mine.
So the process would be, there's an application that they file with the Department of Revenue, and they have to go through all the different steps of giving the information. They give their artwork, and it does have to go through the ALEA visual testing and get those approvals before it actually comes to the License Plate Oversight Committee for us to vet it and approve it.
Okay. All right. Not aware of that.
Senator Coleman Madison.
Thank you. Just for a procedural matter, is this not something that both houses are aware of so people won't continue to make that mistake? I mean, this has come up more than once. And certainly when that bill was introduced in the House, it's out of the House because it's up here. Somebody should have caught it down there. Clerk or somebody should have caught it. So what is the procedure here as far as communication?
Members, I haven't heard some discussion about that. Let's figure out procedurally where we're at, where we should be on this, and I'm going to recommend to the committee that we carry it over for further discussion about that. Any opposition to that?
Yeah. And
then
yes.
Senator Williams.
So I'm happy to explain the process to you with that. We do have 3 House members that sit on that committee as well.
Okay.
Representative Shirey, Representative Ben Harrison, and one more.
can't think. you're
Okay,
right.
because
Is it
nothing was ever
Representative
said
Dana?
on the House
Yes.
about this.
It's 3 and 3 and plus
It's-
paid citizens.
Yes. So
Okay.
happy to work with you to explain
Okay,
the process.
all right, I'll get with you after this.
Okay.
All right, thank you.
Members, having said that, there's a motion to carry it over, a second by Senator Orr. All in favor, say aye. All right, bill's carried over. Just ask y'all to get together to figure out procedurally what needs to
Okay,
happen.
thank you.
Thank you. HB 189, Representative Baker. Are you here? All right, we're going to come back to that. How about, I see Representative Colvin here, HB 226. Now you've got another committee meeting. We're trying
Thank
to.
you, Mr. Chairman.
Yes, sir.
Committee.
Explain your bill real quick for us if you could.
Yes, sir. HB 226. So under existing law, when a defendant in a criminal case enters a plea of nolo contender, a plea of no contest, it's treated as a guilty plea for that specific case, but not for future cases in Alabama regarding our habitual offender law. This bill just closes that loophole. If you have an out-of-state or a plea of nolo contender, which Alabama does not have but other states do, it can be used against you in Alabama to enhance the sentencing. I have
Got a motion for favorable by Senator Bell, second by Senator Elliott in discussion. I'm certain on by Senator Smitherman.
Yeah. Down. So we're adding another layer for the habitual offender?
Yes, sir.
Well, I thought it was kind of like when I was listening to the chairman, I thought that it was something about this habitual offender. I see you getting in, Mike. You probably can know maybe what I'm thinking, but it's something that we found inherently, or the courts or someone, about the fact of the stacking on the habitual offender, and yet we coming back fitting do the same thing. Is that am I on track with what I'm thinking, Senator?
Which one of us you looking at? I'll defer to Bell.
I'm looking at you too now.
I think part of this, when they're doing the sentencing guidelines, we don't have the nolo contendere here in Alabama, so you cannot do that plea in Alabama, but you may have it in other states. So they plea that, and in their state, it's a guilty plea. But in Alabama, we cannot recognize it because we don't, and that's what it's closing that loophole. So when they're running the sentencing guidelines on something and they find, well, back in 5 years ago, you did this, you pleaded nolo contendere in, say, California, and here you are in Alabama, that don't count on the sentencing guidelines as a guilty, and this would close that loophole where it would count as a guilty in when they're running the sentence guidelines. And if we want to get really more in detail, I'm going to put somebody on the spot that's sitting out there. I just happened to look a minute ago when people moved around. I see my DA back there, and I would say he's an expert on some of this just because he's sitting out there and I see him smiling real good. But glad to have my DA, Lyle Harmon, out there, and thank you. But I think it's more closing that loophole from where they commit crimes in other states and come to Alabama, because we do not have a nolo contendere here in Alabama.
Mr. Chairman, if I may.
Yes, sir. Go ahead, and then we'll Senator Albritton.
So my DAs who brought me this bill, we had a specific case in Marshall County. A guy was convicted on 10 counts of sodomy with young boys, and so they got him on all 10 counts in Marshall County in Alabama. However, he did have 6 priors in Michigan, and Michigan is a state where you can plead no contest. And while the circuit judge was trying to make the sentencing, he realized he could not use those Michigan pleas against him because there were no. That's what brought this case forward, to try to close that loophole.
All right, Senator Albritton.
Look, I'm in favor. This is something that we don't recognize, that we are simply codifying that which the courts recognize that we have to acknowledge.
Yes. Exactly.
And so I think we just move forward with it.
We've got a first and a second. I want to make a comment, and quite honestly, this is one that just came to me, even though I looked at it over the weekend, that whether or not any past pleas of nolo contendere, in other words, somebody today may plead guilty to whatever they're convicted of, or whatever they're charged with, not knowing or understanding that previous plea of nolo contendere in a different jurisdiction, another state, thinking that it might not be held against them in a sentencing fashion, either through the guidelines or habitual offender. And so just I wanted to have a discussion about that, whether or not the timing of that, whether or not there's the retroactivity, I understand, is a piece of it, but I just want to better understand that. We've got a first and a second. Any other discussion on the matter? Hearing none. Members in the opposition using previous rule? Hearing none, the bill is given a favorable report. Thank you.
Thank you, Mr. Chairman. Thank you, committee.
Now we're back to HB 189. Representative Baker, you here yet? Anybody handling that for him? All right. HB 37, Representative Ingram. I think Senator Bill, are you handling that for him?
I am, but we're going to carry it over, and we're going to do a substitute. Senator Smitherman, we're going to substitute this. Hopefully, if you'll carry it over to next week, we're going to take what we passed out of the Senate and substitute it for their bill that they brought up here. So their bill's totally different than ours. So that way, it's the bill we've worked through and got everything going.
Okay.
So I want to give everybody a week to at least have the engrossed version of that.
Okay.
Very well. Members, with that being said, again, I'm going to give Representative Baker just a second if you could hang out in here. But if
not you.
Nobody wants to.
I would stand in. He's my dude down in Scambia.
Okay, good, very good. Senator Albritton for Representative Baker on HB 189.
I'd refer y'all to tab number, where are we, 8? And look on pages 2 and 3. It's only 3 pages here. And it looks like mostly just some cleanup aspects dealing with
189.
That's correct. Yes, sir.
Correct.
Tab 8.
Tab 8.
You ready to move?
I'm ready to move.
Second.
Got a first by Senator Albritton, second by Senator Smitherman. Any other discussion? Any opposition using previous roll? Hearing none, bill's given a favorable report. Ladies and gentlemen, that ends Senate Judiciary, which I did not think we were going to get through. See you next
got
week.
us rolling, Mr. Chairman. We were rolling.